people of the state of Michigan versus Alexander Banks Jr. This is case number 26-0191FY. Mr. Anderson is here for the people. Mr. Amadeo, you're here for the defendant?
Yes, I am, Your Honor.
Good afternoon.
Good afternoon, Judge.
And you are Mr. Banks Jr.? Can you hear me?
Yes, yes.
All right. Are you Alexander Banks Jr.?
Yes.
Good afternoon, sir. Sir, it is alleged that on or about February 13th of 2026 in Delta Township, Eaton County, state of Michigan, count 1, that you did deliberately with the intent to kill and with premeditation, kill and murder one HS, contrary to MCL 750.316. This is a felony which carries a maximum possible penalty of life without parole. DNA is to be taken upon arrest. Count 2, it is also alleged that you did carry or have in your possession a firearm, to wit, a shotgun, at the time you committed or attempted to commit a felony, to wit, murder first degree premeditated. This is contrary to MCL 750.227B. This is also a felony which carries a penalty of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of the weapon or device. 3, it is also alleged that you did make an assault upon PS with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony which carries a maximum possible penalty of life or any number of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 4, it is also alleged that you did carry or have in your possession a firearm, to wit, a shotgun, at the time you committed or attempted to commit a felony with assault with intent to murder. This is contrary to MCL 750.227B. This is a felony with a sentence of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Again, mandatory forfeiture of the weapon or device. Count 5, it is also alleged that you did make an assault upon CS with to commit a crime of murder. This is contrary to MCL 750.83. Again, this is a felony with a maximum possible penalty of life for any term of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 6, it is also alleged that you did carry or have in your possession a firearm, to wit, a shotgun, at the time you committed or attempted to commit a felony, to wit, assault with intent to murder, contrary to MCL 750.227B. Again, this is a felony with a sentence of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of the weapon. Count 7, it is also alleged that you did make an assault upon BC with intent to commit the crime of murder. Again, contrary to MCL 750.83. This is a felony with a maximum possible penalty of life for any number of years. DNA to be taken upon arrest. A sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 8. It is also alleged that you did carry or have in your possession a firearm, to wit, a shotgun, at the time that you committed or attempted to commit a felony, to wit, assault with intent to murder, contrary to MCL 750.227B. Again, this is a felony with a penalty of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, mandatory forfeiture of weapon or device. Count 9, it is also alleged that you did with the intent to use the same unlawfully against the person of another, though armed with a firearm, to wit, a shotgun. This is contrary to MCL 750.226. This is a felony with a maximum possible penalty of 5 years in prison and or a $2,500 maximum fine. Again, mandatory forfeiture of weapon or device. That's commonly referred to as carrying with an unlawful intent. Count 10, it is also alleged that you did transport and possess in or a loaded firearm, which was not a pistol, to a shotgun, contrary to MCL 750.227C. This is what we call a high court misdemeanor. The maximum possible penalty and or a 2 forfeiture of weapon or device under MCL 750.239. A loaded firearm in or upon a vehicle. Sir, do you understand the nature of the charges and their maximum possible penalties?
Yes, I understand.
You do have the right to remain silent. Anything you say, orally or in writing, can be used against you. You have the right to an attorney like you have one here today. If you cannot afford your own, one will be made available to you at public expense. You also have the right to have your attorney present at all further appearances before the court and at all further interrogations by the police. In a felony case, you have the right to what's called a preliminary examination hearing. At that hearing, the prosecutor is required to present proofs to show probable cause to believe that a felony has been committed and probable cause that the person committed that felony. So at the end of the hearing, if the proofs are strong enough, the matter would be bound over to circuit court for arraignment and trial. If they are not strong enough, the case could be dismissed. Further, you do have the right to be presumed innocent of these charges and have the state prove the charges at a trial by a judge or a jury beyond a reasonable doubt. Sir, do you have any questions about any of those rights?
No.
Mr. Amadeo, how is your client pleading today?
At this point, Your Honor, my client will stand mute, waive any other formal readings.
Thank you. On behalf of the defendant, Mr. will enter a not guilty plea on his behalf. And we will set this for a probable cause conference on March 2nd at 8:30. And because the defendant has the right to have a preliminary examination within 21 days of the date of arraignment, we will set the preliminary examination for March 9th at 1 o'clock before this court.
May I speak on that briefly when appropriate, Judge?
You may go ahead.
You know, we're going to waive all statutory timeframes. I'm not asking for bond today. I do have a competency filed. I did speak to Prosecutor Anderson about that. I don't know if it would be appropriate to ask you to sign it today, but we are going to waive everything and ask for a forensic.
Any objection to the waiver of the 21 days, Mr. Anderson?
No, Your Honor.
Very good. The court will then not set a prelim within 21 days. Filing for competency.
That's correct. I do have an order now if I can approach.
You may. Go ahead, Mr. Amadeo, if you'd like to speak to bond, and then I'll let Mr. Anderson respond.
Your Honor, at this point, I have spoken to Mr. Anderson. I know the people requesting bond. At this time, due to the forensic, I'm not going to request any bond.
Thank you. Mr. Anderson.
Your Honor, I would ask, pursuant to MCR 6106B1, that the court deny bond and new trial. It does fall under, count one falls under the category of offenses for which bond can be denied. I also, based on my knowledge of the case at this point, have no objection to the court signing the competency evaluation. Both reasons matter. If you come back and do it in 2 weeks, we can do it today.
Very good. Based on all that, the court is going to not give any bond to Mr. Banks at this time. No bond. Because there has been a petition and a proposed order filed for competency, and based on their essentially a stipulation between both the prosecuting attorney and the defense attorney that Mr. Banks go under the Michigan Forensic Center, the court will sign that order. So therefore, because he will be undergoing a competency evaluation, we will not have the probable cause conference that is canceled. We will as to when we can get him in for competency and get an evaluation completed. I have signed the order for that competency evaluation.
Judge, I would just ask for a 60-day, marker date.
Is that all right? with
No problem with
Ms.
that,
Arroyo?
Judge.
Can you please check your calendars for mid-April? That first, or I apologize, the third Monday in April, April 20th,
What time would you like, Your Honor?
8:30?
I'll make that work, thank you.
That's fine.
That's good for people.
Very good. All right, we will call that essentially, I guess we will call that a probable cause conference / review hearing and see if the forensic center has seen Mr. Banks yet. Thank you. So it'll be April 20th at 8:30.
And Judge, forgive me, I've been to your court. Will you take care of the copies, or do you want me to mail it in or email it to them?
We will send it to the forensic
Thank you.
center. Thank you. Anything else for the record from the parties?
Thanks for giving us in today, Judge. Nothing else from the defense.
Nothing to do, thank you.
Thank you. That's all for the record.
Hold me, sir.